The big news institution-wide at the ICC is the staff turnover. Starting with the prosecutor position, the chief prosecutor, they have created essentially a committee to accept statements of interest from potential new chief prosecutors. And the front runner is someone who we've met and had an opportunity to spend some time with, Beth Van Schaack, who's now the deputy prosecutor. Other candidates in play have been, of course, everyone else that is sitting at this table and others who are here, former chief prosecutors and current chief prosecutors of the other tribunals. Interestingly, one of the most obvious candidates would have been Hassan Jallow, who's the chief prosecutor of the Rwanda tribunal. He, however, is barred from the position so long as Fatu is the deputy prosecutor. I've got the text here, but one of the requirements is the deputy and chief not be of the same nationality, and both of them are from the Gambia. Who knew that the Gambia was such a font of fabulous international criminal law jurists, but as it turns out, that's indeed the case. So he has withdrawn, he's not in formal considerations for that role. It will be difficult for some of the other chief prosecutors to leave their institutions at this point. As we'll talk about, there's been some really exciting and important developments there. It's really the swan song period of those tribunals. There's lots of important defendants that the courts now have jurisdiction over, they have custody of, and so it may be difficult for these individuals to leave their institutions at this particular moment in time. So that has opened up for consideration of other jurists, individuals who are members of the international community, the human rights community, some of the human rights institutions, to put their names forward. To date, we do not have that list. It will be released sometime in the next couple of weeks, so you can keep your eyes open for that. Judgeships. There are 6 judgeships now open. This is also the subject of an ongoing process whereby states can nominate their nationals. And you have to be a member of the court in order to be able to nominate someone for a judgeship. So we have a search committee. And there's some really troubling and worrisome developments in this process. Number one, the court is supposed to have individuals on the bench who have either criminal law experience or law of war / human rights experience. And they sort of are considered into 2 camps, and they want to keep a kind of an equal balance between those camps. Almost everybody who's now on the list, 9 of the 10, have criminal law experience. There's only one person who can really credibly claim to have humanitarian law, human rights experience. Also on the diversity front, there are no women on this list, as may be obvious from the names. The statute mandates that there be a fair representation of both men and women on the bench. We've got a great representation at the moment, but 3 of the 6 who are now having to step down are women, and no women have been put forward yet. The nomination period is still open, and so there's some rumors that the Philippines and others may have candidates percolating in there, but we're still waiting to see who those final names will be. We also have concerns about the process by which the judges will be chosen. Of course, many people in the field are hopeful that it will be a meritorious decision based upon individuals' qualifications, etc. What we know about the international system is often this is a very cynical case of vote trading, right? We will support your candidate for the ICC if you support our initiative here, or our candidate for this position, or etc. And so there is this sort of sense that that kind of a process may take over, and that would obviously be very unfortunate. As Professor Amon mentioned in her talk last night, or at the end of her talk, and the punchline was, it's important to get good people in these positions, and that will not happen if we do this by virtue of vote trading. It really has to be based on the merits. Africa and Europe are well represented in terms of candidates. Asia has not put forward a candidate, and so if the Philippines does so, that would be an important development. Also up for grabs is the head of the Assembly of the States Parties, which is the political body of states that have all joined the court. So, for example, the United States is an only observer at the ASP because we've not joined the court, although we have signed the treaty. And the bureau, which is the sort of, political body within the political body, has nominated this gal, Tina Intelman, who's the Estonian ambassador. She would be the first woman to run the ASP. She would be taking over from Christian Wendreiser, who was from Liechtenstein and actually a very, very strong tenure as head of the ASP. He was in charge of the aggression negotiations, etc. And so she's likely to be the individual who would take over that position. So turning to our situations, this is a map that shows the active situations, except one. Wikipedia has let us down. Libya should also be in red, and I checked as of Sunday as I was getting on the plane, and they still had not updated it yet. I don't know how to do that. So if any of you know how to get into Wikipedia and mess with these things, you can add Libya to the list. Obviously, the first thing is that they're all in Africa, which is partly why both Fatou Bensouda and Hassan Jallow were really considered sort of front runners for the position of chief prosecutor, because all the situations do come from Africa. And this has created some tension within the African Union, which is the political body of all African states. From the beginning, the African Union was very supportive of the court. Something like 31 of 53 states in Africa have joined the court. They've been very active in the review conferences. But with the indictment of President al-Bashir of Sudan, that soured the relationship with the AU, and the AU has made some formal statements calling upon member states not to cooperate with the court, notwithstanding that by virtue of joining the court, there is a pledge of state cooperation in the treaty, so that all states have pledged to cooperate. And so there's a real tension between the AU formal position that has been taken and what treaty obligations exist. In addition, there are UN charter obligations. Because the Sudan situation was forwarded to the court by the Security Council is the sort of executive body of the United Nations, all states are obliged to cooperate with and to implement decisions of the Security Council. Now, the AU does not speak with one voice in this regard. There are individual member states like Botswana, etc., who have come out in support of the situations that are now pending before the court. And so there's a real internal struggle happening within the AU. So there are three ways in which situations can come before the court. A state can refer a situation, the Security Council can refer a situation, and the prosecutor, acting on his or her own determination, can initiate an investigation, having to go through a sort of a hurdle of the pretrial chamber. And as this chart shows, 3 of the 6 situations were state referrals. Now, what's interesting about this is when that was designed back in Rome, the vision was that one state would refer another state, for example, a neighbor state where atrocities were happening, or a Good Samaritan state where the European states would refer one of the, an African state or a Latin American state where there was an internal conflict happening. And what has been surprising to many is that the way in which the state referral mechanism has been used is that states have actually referred themselves. So all 3 of these situations are so-called self-referrals, where Uganda, the Democratic Republic of Congo, and the Central African Republic have said, we can't handle the justice implications of the atrocities happening in our midst. We need help. We want to refer the situation to the court. It was somewhat controversial. The court has just breezed over that and has accepted those situations and is hearing those cases. The Security Council has referred 2 cases, as you see, and the prosecutor has initiated 1 case.